If you only knew the power of the dark side, it is your destiny.
Hello everyone, this is Take the Gate. It is September 19th, 2014, and I'm bringing you an article off of Reality Check, and it is written by Anna Maria Satya or Sakya, and it is titled Ohio's Conflicting Statutes Create Obstacles for Some Abuse Survivors, and it is about a woman who was 14 years old at the time when her abuse occurred. It was between 2000 and 2001 from multiple guards at the Ohio state-run Scioto Juvenile Correction Facility. And she was sexually abused and raped over the course of a year while in custody. And her lawyer, Jill Flagg, is asserting that she has the right to file a civil lawsuit, seeing as though that Watkins turned 18 in 2004. 10 years later, he gave her time to process it, which would put her about age 27, 28. And it says that her essential character is the case as a childhood sexual abuse, meaning that Ohio's much longer window to pursue those civil claims, 12 years past the majority age, should apply under that law. Watkins would actually have to wait until 2016 to file her lawsuit. The court is essentially trying to dismiss her claims of child sexual abuse, which leaves the door open to interpretation on the court's end. So it says here, Watkins appealed to the Ohio Supreme Court last September, claiming disparate application of the two statutes violates Watkins' constitutional rights in the court. Heard oral arguments in April of this year. The justices have not indicated whether they will hand down a decision. According to Mason, Ohio-based attorney Conrad Kircher, this is the first time the state's highest court is interpreting the issue of sovereign immunity in child sexual abuse cases, but he noted that the statute of legislature is only implemented in the 12-year statute of limitations, and that's the state legislature only implemented the 12-year statute of limitations 8 years ago, making the law still fresh in jurisprudence. Still, it says that they have pursued dozens of survivors' rights cases among Ohio's clergy scandal in the early aughts. And it doesn't surprise Kircher that the Supreme Court took the case. He says, no, I mean that there is an apparent contradiction between the 2 years and the 12 years. So they have effectively are opening this door to child rape by guards to protect the guards. So if there is a child in the juvenile facility and that child has 2 years to apply for a civil lawsuit instead of the actual 12 or more, they're claiming it's 16. So it would make these juvenile facilities even worse than they are under the PRENA laws, Prison Rape Elimination Act. And by doing so, they are basically giving the guards carte blanche to rape whoever and whenever they want in any dark corner in these facilities. And they have 2 years to bring it to court. And these are different cases if you want to take a look at it and look through, and they cite them as under the 14th Amendment, equal protection under the law. And as far as I know, a juvenile cannot bring a civil case if they are 14. So it's highly dubious that the court would accept such ruling. But, like I said, we have a judicially captured Ohio court. And when that happens, they will tend to side in favor of their corporate masters for the bottom line of Wall Street. So I will leave a link and description to the comments below. It's a lot to read, and I hope that you will take a look at this, because your child could end up in these child abusers' clutches, and this is one of the main ways, besides the foster care system, that abusers find their victims and child rape victims. So this is Take the Gate. Please comment, rate, and subscribe. Thank you for watching.